Mr. William Miller. All right, can you keep this microphone hanging right here in the middle, please? Is that microphone hanging right there? Hey, if you can stand right there. All right, Mr. Miller, my name is Judge Payton, and this will serve as your bond hearing. The purpose of the hearing is for me to inform you of your rights, the nature of your charges, and to set your bond. Once I set your bond, it can be met in 4 ways. First, if I indicate that it's a personal recognizance bond, then you can sign yourself out without having to pay any money. Secondly, you can pay cash directly to the court for the full amount of the bond. If you pay the full amount of the bond to the court, once you appear for your court date, you'll get all of that money back. Third, you can obtain a bondsman. If you obtain a bondsman, they will charge you about 10% of the total amount that I set. And lastly, you can put up property. If you put up property, it has to be located in Greenville County, and it cannot be a vehicle or a mobile home. As for your rights, you have the right to remain silent, so anything that you state here can be used in any future hearings or trials, as everything here is recorded as evidenced by the red light above. You also have the right to an attorney. If you cannot afford an attorney, you have the right to have one appointed to you. If you wish to be screened for appointment of an attorney, if you release, that process is done at the Greenville County Courthouse through the Public Defender's Office. If you're not released, that process is done here at the jail. You also have a right to a trial by a judge or a jury, and it's your right and obligation to appear at any trial that's scheduled for you on these charges. Failure to appear for a trial can result in an additional criminal charge being lodged against you. Failure to appear for a trial on a misdemeanor carries a penalty of $1,000 or 1 year in jail. Failure to appear for a trial on a felony carries a penalty of $5,000 and 5 years in jail. You have a general sessions or circuit court level charge, which means that you're entitled to a preliminary hearing. At the preliminary hearing, the prosecution is required to present any evidence that they have against you to a judge, and the judge at that time will determine if the state has enough evidence to continue to move forward against you. If you wish to have the preliminary hearing, then that request has to be made within 10 days. If you fail to make that request within 10 days, then you lose your right to the preliminary hearing. And if for any reason these charges are dismissed, not prosecuted, or you found not guilty, then you have a right to have these charges expunged or removed from your criminal history. And lastly, it's your responsibility to keep the court abreast of any changes that may occur with your contact information, as that's the only way for us to inform you of court dates, trial dates, or other information. So if your contact information changes and you do not update the court, you'll still be held accountable or responsible for any notices that go to old or changed addresses. So everything that I've just gone over, you'll receive on your paperwork at the end of this hearing, so you'll have this information at your fingertips, and you'll be asked to sign and initial confirming that you received this information both verbally and in writing. All right, Mr. Miller, you've been charged with assault and battery 2nd degree. This is a misdemeanor which carries a maximum penalty of 3 years incarceration. Is there anybody from the family that would like to address me regarding any issues?
I don't think it should be assault. I think it was trauma resistant or something like that. But she actually slapped her on the butt. Like she came home from me crying, said the judge just slapped her butt. He gave her a hug. He been hugging her for 2 years. He gave her a hug. He slapped her butt. After that, he won't touch his flag. Gave her after her another hug. Slapped her butt again. Told her that he needs her in his life. He loves her. Okay, because she come home with him. That is not assault. That is sexual assault with anything.
Yes, ma'am. All right, Mr. Miller, your bond amount on this charge is $50,000 cash or surety. The condition of the bond is to not have any contact with the victim directly or indirectly. You're not allowed back at the school, or you're on no trespass notice at the school, and you'll be placed on GPS monitoring. If you have any questions, issues, or concerns? Can you come a little closer to the microphone, please? I could go ahead. All right.
This one, I'm going to use the law in the paperwork that I want to see at the end.
Yes, sir. So what will happen in just a second, if you don't have any further questions, or once you don't have any further questions, my clerk will bring some paperwork to that window to your left, and you'll be able to sign and initial the paperwork. Do you have any other questions? Is that your only concern?
At what point could I address the accusations? Is that something that we do at the trial?
So you have a right to a preliminary hearing. Preliminary hearing, the prosecution will have to present to the judge what evidence they have against you, and you and or your attorney will be able to ask questions at that time. You also have another court date if it goes that far. However, in terms of conversation with the solicitor or whatever occurs at the preliminary hearing, that's when you'll be able to kind of assert a defense or anything like that that you may have on your behalf. All right. Any other questions? All right. Please got to adjust some paperwork. One quick second, and then to have it at the window to your left. All right. Any questions, issues, concerns from the family?
This form, you can initial 2, 3, 4, and 5. And your signature right here.
Judge, the family has a few questions they actually asked. One in particular is how do they know that he won't be returned to the school? Another question that they had was, well, basically the statement they wanted to make was anytime a trial or hearing was scheduled, they want to make sure that someone contacts them. But they're very concerned about him being in contact not only with their child, but also with other children at the school.
So as for the initial question regarding him coming back to the school, he's currently on administrative leave, and the condition of the bond is that he not return. So he's on no trespass notice. So going back would be a violation of the condition of the bond. Regarding the second question, repeat that for me again.
They just want to make sure that they're informed of any hearings.
Right, so just like this hearing, any hearing moving forward, the victim or victim's family in this case will be notified for every hearing going forward. They will have the opportunity to be present at any hearing moving forward. So that's just kind of state law that's required in every case where there's a victim.
And also, will they be informed when he's released?
Yes.
Yes, they will. They will.
Thank you so much.
Yes, ma'am.
These are just your copies, and this will return you. All right, and you're free to go.